An estimated 1.6 million Americans over the age of 13 identify as Ts, and that is a big number. Medical treatments and procedures are uniquely bound up in sex. In fact, the FDA itself recognizes that there are biological differences between men and women. Oh my gosh! Whoa! Saying the Sixth Circuit says that the Ts are not a suspect class, and it was right to do so. Wow, Amy Coney Barrett coming out hard against the Ts. Major ruling from the Supreme Court. The trans not happy about it at all. They are mourning the loss in this case. United States versus the Attorney General and the reporter for Tennessee. The state of Tennessee passed some laws regarding transitions of minors, and the United States in a prior generation, in a prior DOJ, came out, sued them, said, how dare you govern yourselves? We're the DOJ, and if we want to transition minors, we're going to do it. And they did it for about 4 years. So now the Supreme Court has come back down and issued a ruling, and it's a contentious one, 6-3. And let me just show you, this is from the head note, but it was contentious. And you can see here is the breakdown on how the judges ruled. So the Chief Justice, Roberts, is going to be delivering the opinion of the court, the main bulk of the decision. And you're going to see this thing where some judges are agreeing with part of Roberts, but not other parts, and coming to their own conclusions. And so the breakdown goes like this. Thomas, Gorsuch, Kavanaugh, and Barrett all joined, so they're in the majority and basically in total agreement with Roberts. Then Alito joined as to a couple parts. He says, well, I like part 1 and I like 2B. The rest of it's crap, John. And then Clarence Thomas comes in and he says, actually, I'm just going to write my own opinion. I'm going to concur in the opinion. Same thing with Amy Coney Barrett also, right? And then Clarence Thomas is joining Amy Coney. So then they're all kind of agreeing, right? Thomas agrees with Roberts, but he's also saying, well, I got to write my own. And then he writes his own. And then Amy Coney Barrett writes her own. And then Clarence says, that's pretty good too. So he's joining over there. Then Alito filed his opinion, concurring in part and concurring in the judgment. So he says, I agree with some of the concepts from Roberts, but ultimately I definitely agree with the outcome. So the rationale, how he got there might be different, but I agree with the end game. Now, Sotomayor and the libs, right? 6-3. So we got the 6 here kind of in this contorted little pretzel, but all agreeing. And then we've got Sotomayor. She dissents from the left. Jackson Ketanji, who got a $2 million book advance, she joined that in full. And Kagan, she joined as to a couple parts of that. And then Kagan filed her own opinion. So I was like, golly. So a lot of stuff happening here, but the ultimate decision, 6-3, Tennessee wins and the T's suffer a setback. Here is the breakdown now that matches a lot of that. Coming from Chief Justice Roberts, Supreme Court of the United States, drops the opinion of the court, asking a very important question. In this case, the question is, and what they consider is whether a Tennessee law banning certain medical care for T minors violates the Equal Protection Clause of the 14th Amendment. 14th Amendment was a big one. After the Civil War, part of the Reconstruction Amendments, we've got a lot of stuff that got shoved in there, including birthright citizenship, equal protection, incorporated down to the states, and more. So here's what Roberts writes for us. Coming from SCOTUS, he says, an estimated 1.6 million Americans over the age of 13 identify as Ts. And that is a big number. And I wonder how that number came about. Like, when did it get to 1.6? Like, if you were to graph that on a little chart here, and you had the number on the y-axis and time on the x-axis, what does that number that gets us up to 1,000,006 look like? What is that? And what year was this where we saw this massive up and to the right? Don't know, but seems like it's probably pretty recent. Now, anyways, saying their gender identity does not align with their biological sex. Some Ts suffer from gender dysphoria, which is a medical condition characterized by persistent, clinically significant distress resulting from an incongruence between their ID and their body. Left untreated, it can result in severe physical and psychological harms. Background: in 1979, the World Professional Association for the Ts, known as the Harry Benjamin International Gender Dysphoria Association, published one of the first sets of clinical guidelines for treating this, and it was reprinted in a bunch of things. The standards address 2 treatments in particular: hormonal reassignment and surgical reassignment. In 1998, another group revised its standards to permit healthcare professionals to issue blockers, right? You take the drugs now, and said that you could even delay the development of physical characteristics on minors in rare circumstances, and that you should should maybe do it. Today, the standards discuss a range of factors regarding the provision of treatment to minors. The current standards do recognize known risks associated with the provision of these transition treatments, including adverse effects on fertility, the possibility that the adolescent will later wish to detransition and can't really do that anymore. Now, they further state, writes John Roberts, that there is limited data on the optimal timing of this. So when should you chemically neuter them? When is the appropriate time? Oh, I don't know. How about never? In recent years, the number of minors requesting transition treatments has increased, just like we suspected in our little graph. This increase has corresponded with rising debates about the relative risks and the benefits of this. Is it doing anything? Is it stopping them from killing themselves or dying or being attacked or whatever? In the last 3 years, more than 20 states, not playing, have enacted laws banning the provision of transition treatments to minor kids, while 2 have enacted near total bans. Now, meanwhile, health authorities in a number of European countries have also raised significant concerns about the potential harms associated with the blockers to minors. In 2020, Finland came out and found that gender assignment of minors is an experimental practice, experimenting on kids openly in clinics. Like, you call and schedule an appointment. Can you experiment on my child? Sure, happy to. We'll also bill you about 7 figures for it too over the course of their lives. Saying the same year, England and National Institute for Health reports finding that the evidence of using blockers to treat transgender adolescents is of very low certainty, and that there are long-term risks associated with using hormones to treat kids, and saying actually the consequences of this are largely unknown. In 2022, Sweden's National Board of Health and Welfare also found that evidence on treatment efficacy and safety is still insufficient and inconclusive. That's okay. Just keep lopping them off, chemically castrating all these boys. Saying in 2023, the Norwegian Healthcare Investigation Board concluded that the research-based knowledge for this is insufficient and long-term effects are little known. Well, we're going to know them in a few years. Now, in March 2023, Tennessee had enough. They joined a growing number of states saying this has gone insane, restricting transition treatments for minors. Many places, they want to do it even without parental consent, start to transition you on the school bus on the way into school. Saying while the state's legislature acknowledged that discordance between a minor's gender identity and biological sex can cause discomfort and distress, it did identify concerns regarding the use of blockers in particular. Saying the legislature found in Tennessee, right, they're close to this issue, they know what's going on. They found that these treatments can lead to the minor becoming irreversibly sterile, having increased risk of disease and illness, and suffering from adverse and sometimes fatal psychological consequences. And you can look at the suicide rates for this group. Saying they lack the maturity to fully understand what it means when you castrate their genitals. These consequences and may later regret undergoing treatment. Yeah. The legislature was also finding that the treatments were being performed on and administered to minors in the state with rapidly increasing frequency. It's a whole industry. Notwithstanding the fact that the full range of harmful effects is not even known. The legislature also noted that guidelines about these treatments for minors had changed substantially in recent years. Sweden, Finland, UK placed severe restrictions on these treatments after there was no evidence discovered that it actually helps anything. Finally, the legislature determined that there is evidence that gender dysphoria can be resolved by less invasive approaches that are more likely to result in better outcomes. Yeah, but that's not what they want. They want to, irreversibly change the kids because it's part of the recruitment operation. SB1 responds to these concerns by banning the use of certain medical procedures for treatment of trans minors. In particular, the law prohibits a healthcare provider from surgically removing any tissues or organs on a human being, okay? No chopadicophomies happening here. Or dispensing any puberty blockers or hormones, okay? So 2 things, surgery and puberty blockers, which is wild. You have to even, think about that. When you're like 13 or 12, they're going to talk about, anyways, wild times. Enabling a minor to identify with or live as a purported identity inconsistent with the minor's sex, to change them, or treating this discomfort through those mechanisms. Among other things, the prohibitions are intended to protect minors from physical and emotional harm by having some maniac doctors in there with scalpels, by encouraging minors to appreciate rather than become disdainful of their biological sex. Weird, talk to them through it, kind of understand what's going on and correct the dysmorphia. SB1 is limited in 2 relevant ways. First, SB1 does not restrict the administration of blockers or hormones if you're over the age of 18. You're an adult, you want to go do all this stuff, do you enjoy? Second, SB1 does not ban fully the administration of the drugs to minors. In fact, the healthcare provider provider may administer these blockers to treat a congenital defect, precocious or early puberty, disease, or physical injury. Okay, so for other reasons, it's just you can't do it to transition someone's status. Now, the law defines the term to include abnormalities and more. It also contained 3 primary enforcement mechanisms. Here's what it says. The Tennessee Attorney General can bring an action against anybody in the state who's doing these procedures on the minors, and allows discipline for healthcare providers that are a part of it, and creates a private right of action that says, well, if you're an injured minor or if you're a non-consenting parent of an injured minor, you can sue for that and get damages. Now, 3 T minors are the ones who brought this lawsuit. John Roberts writing here for the majority of the Supreme Court, saying 3 of the T's came in. Their parents and doctors brought a lawsuit. They said, you can't do this. This is discriminatory. This law is singling out the T's, just like the military was singling out the T's, and we are being denied our due process and constitutional rights. So they moved for an injunction to prevent the ban from going into effect. United States government intervened and said, well, we're going to step in on this, right? The prior DOJ. Now, the district court partially enjoined enforcement of the prohibitions. So lower level district court said, well, you lack standing, but we still think that they're going to succeed because the T's are a quasi-suspect class, and so they deserve intermediate scrutiny. Now, the Sixth Circuit reversed. Sixth Circuit said the United States and the plaintiffs were unlikely to succeed. It's actually not equal protection. They said the lower level court missed it. This isn't a law about the T's. This is a law about the minors, and therefore the T's lose. Judges dissented down there, and then we got to the Supreme Court. Here we are. John Roberts for SCOTUS writes, the 14th Amendment and its command that no state shall deny to any person within its jurisdiction the equal protection of the laws must coexist with the practical necessity that most legislation classifies for one purpose or another with resulting disadvantage to various groups or persons. So we got to kind of do this analysis because a lot of people are going to say that they're being denied equal protection. So we got to go in, what is the basis of the law? Supreme Court says, we have reconciled the principle of equal protection of the law with the reality of legislation classification. So what bucket do we go into? If the law burdens a fundamental right or if it targets a suspect class, which are the 2 categories we just explained. Your right to vote, for example, your right to free speech, for example, or if you are a part of a group that has a special law targeted against you, which we used to have. We will uphold that classification so long as it is rationally related to that legitimate end. So what are you trying to achieve? Is this a law to attack the T's or is this a law to protect the minors? We generally afford these laws wide latitude under this review, acknowledging that the Constitution presumes that even improvident decisions will eventually be rectified by the democratic process. And this is kind of the principle that we've seen be destroyed over recent months by the other courts. It's this presumption of good faith. You just kind of presume that the government is acting in accordance with the law, and if the people are unhappy about it, they can impeach the president or vote for other Congress people who can impeach the president or whatever. But that has been thrown on its head. Now the courts are acting in the opposite manner. So the court continues explaining. Certain legislative classifications, however, prompt heightened review. We go into the strict scrutiny bucket. For example, laws that classify on the basis of race, alienage, or national origin, where you came from, that means we go up to that high bucket, strict scrutiny. And they're going to pass constitutional muster only if they are suitably tailored to serve a compelling state interest. We have also held that sex-based classifications, like women, you'll notice in this strict scrutiny class, right? Like you didn't hear gender in this list of strict scrutiny because it's not in there. So when it comes to gender, it was in this like middle class. And this is why this case I think is pretty important, is because now it's like, do the T's fit into this intermediate scrutiny standard? Saying, while our precedent does not make sex a proscribed classification, we have explained in other cases, kind of carving out this middle category, where sex generally provides no sensible ground for differential treatment. Like, how can you treat men and women differently in the law where it works? Saying that sex-based lines are often based around stereotypes leads to broad generalizations between men and women. And so accordingly, we subject laws that contain sex-based classifications to this middle category called intermediate, right? So certain at the top, gender in the middle, everything else rational basis. Saying that you have to show why you need to be in that category, and for that standard, it goes from necessary government compelling and necessary, to a lower standard, which is easier to meet. It just now has to be important. So it's not necessary and compelling, it's just important. If it's important, you can do it. And it's got to be substantially related to the goals. Now, we're now asked to answer this question. Do the T's, and more specifically, does the law, as it is encroaching upon the T's claims, does it actually target them in a way that warrants strict scrutiny? And the Supreme Court comes back down in a ruling, 6-3, says, we hold that it does not. SB 1 does not classify the T's on any basis that warrants heightened review. So it's going to be at that lower standard review, rational basis. T's are not even getting intermediate scrutiny. Let's go through it. On its face, SB 1 is talking about two classifications. One, age, not gender. Healthcare providers may administer certain treatments to people who are over 18, but not to minors. And second, it also talks about the basis of the medical use, writing healthcare providers may administer blockers or hormones to minors to treat certain conditions, but not gender incongruence. And so these classifications are about age. They're about medical use. And so that means they only get rational basis review, the lowest standard of them all, which means this can now be copy and pasted to all of the other states. And the T's can't say you're discriminating against me because I'm a T. No. It's about ages and medical conditions and use. And so you're not going to be doing that to minors. So it's a powerful and broad ruling, right? This is saying that as long as these laws are not specifically targeting the T's, they're valid. All we do is analyze them according to rational basis review. Now here, the plaintiffs also argue, the T's, that SB 1 warrants heightened scrutiny. They say we should be up because it's about sex, it's about gender. But neither of the classifications are about sex, says John Roberts. It's not about that. SB 1 prohibits healthcare providers from administering blockers to minors, and it does it for medical use. Nothing about your sex or your gender. They resist this. They say, no, but it's ultimately about it. They say it creates classifications by defining medical care based on their sex. But this argument, they says, is unpersuasive. This court has never suggested that mere reference to sex means you get heightened scrutiny. It's not our case law. Medical treatments and procedures are uniquely bound up in sex. In fact, the FDA itself recognizes that there are biological differences between men and women. Oh my gosh! Whoa! Democrats blown out all over the country reading this. You can't say that. We also reject the argument that this turns on sex at all, the law. The plaintiffs and the dissent, with all the libs, they say that an adolescent whose biological sex is female cannot get blockers and present as a male, but a male can present as a female. Don't even know what they're talking about. It's not even worth trying to parse through it. So conceived, they argue, that it's actually discriminatory. All right, so males to female get certain benefits and females to male don't. All right, so the plaintiffs and the dissent, however, are contorting the meaning of the law. Notably absent from their dissent is a key aspect of any medical treatment the underlying medical concern is intended to address. In fact, the FDA approves drugs and requires they be labeled for specific people. Different drugs can treat the same thing. And for medical treatment, it's about what's being administered. When properly understood from that perspective, SB 1 is not being classified on the basis of sex. And it's not incongruent. Under SB 1, they can administer blockers for certain conditions that are exceptions to the law, like congenital defects. But this is not a sex-based classification. The law does not prohibit conduct for one sex that it permits for another, like only dudes can do this, but females can't. No minor may be administered. None. Doesn't matter if you're male or female or in between. Doesn't matter. You're not getting treatment, this so-called treatment, or being poisoned. Nor are we persuaded that the prohibition on the prescription is enabling somebody to not live in conformance with their gender. Saying such a law would be just like other religious prohibitions that we have rejected. So John Roberts continues going through their arguments, and the next main argument is saying that they're a quasi-suspect class, right? Gender incongruence. We don't really know what the trans are. They're kind of in between strict scrutiny and rational basis, so we'll call them a quasi-suspect class and protect them under that basis. John Roberts says no. Under these circumstances, we decline to find that any of these prohibitions, like on the blockers or hormones, exclude anybody on the basis of their trans status. It's about limitations on minors. And finally, our prior case in Bostock versus Clayton doesn't alter our analysis. There was a prior trans case and everybody's going, what? In that case, that was about somebody who was being fired because of their sex. Now, we reasoned because of that if there's discrimination in the workplace, they've penalized one person for a trait against the other people. And so that was a violation of equal protection, but that is not being extended here. The dissent's reasoning overlooks a key distinction. Under Bostock, an employer who fires a homosexual male for being attracted to men while retaining the employee's straight female colleague has discriminated on the basis of sex because he's penalized the male for a trait, which is attraction to men, that it tolerates for the female employee, right? A difference of treatment between men and women. That's not what's happening in Tennessee. Consider this again. The minor girl with unwanted facial hair inconsistent with her sex. If she has a diagnosis of male pattern hair growth, a healthcare provider may, consistent with the law, prescribe her blockers. But changing her sex to male does not automatically change the operation of SB1. If the hair condition is treated, that would be the same. Unlike the homosexual male employee who was fired, it's different because it's being applied equally to address conditions of the minor. And so SB1 meets the standard of rational basis review. It's a very low standard. They've determined in Tennessee that the hormones and all of this can lead to real big problems for the minors. Tennessee determined by their own legislature that minors lack the maturity to understand any of this. And Tennessee noted that there are less invasive procedures instead of laparotomies that can help a child who is suffering from this problem. The plaintiffs argue that this doesn't even survive rational basis review. Like, it's so egregious that it can't even survive that low standard. Not true. We decline this invitation to second guess what the legislature has created. They go through and make their analysis, and it seems rational to us. So we're not going to second guess it. Recent developments only underscore the need for this, by the way. After Tennessee enacted SB1, a report came out from England, their National Health Service, characterizing the evidence concerning the use of puberty blockers as remarkably weak, saying there's no good evidence on the long-term outcomes of any of this. In response to the report, NHS in England enacted prohibitions on the administration of puberty blockers outside of 18. Only our country is insane enough to continue it. We cite this report and England's response not for guidance on the ultimate question, but just to show you there are open questions about this. Some of these medical kooks can say that it's cut and dry, that, these kids are going to off themselves or something and prescribe their, little mutilation operations, but that is not settled science, okay? Now, this case carries with it, says Roberts, the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. The voices in these debates raise sincere concerns. The implications for all are profound. The Equal Protection Clause does not resolve these disagreements, nor does it afford us, the Supreme Court, license to decide them as we see best. Our role is not to judge the wisdom of the law before us. Gosh, yeah, right. Saying, having concluded this doesn't violate the 14th Amendment, this is a policy that should be left to the people, their elected representatives, and the democratic process. And so the judgment is affirmed. The T's are not being treated in this provision under this law as an intermediate quasi-suspect class at all. It applies to minors. Rational basis review is appropriate. Now, Thomas came out, big fans of Clarence. He said, today the court was correct. It is only rational basis review. But I want to address some additional arguments in defense of Tennessee law. He says the Equal Protection Clause includes none of this language that goes into any of the T's or any of the Bostock. He's also shredding the prior case. Extending this framework here would depart even more dramatically in other ways. And this has been rightly rejected, saying the United States came out and asserted that the medical community overwhelmingly agree with our position that you should be able to do this to kids. But there are several problems with this. We should not defer to the expert class, says Thomas. He's right. And second, contrary representations have also been presented, saying there is no medical consensus about how best to treat this. These are irreversible. And fourth, there are good reasons to question the expert class because they're all in on the grift, getting rich off of it and securing political power off the back of the kids. Disgusting. So next we got Barrett. She says, because this court concludes that the bill does not classify on the basis of status, it does not resolve whether the T's are a suspect class. And I write separately to explain why, in my view, it does not. Only a few exceptions to the rule. And the court has said we're not adding additional people to strict scrutiny. And we're not going to do that now. Saying the Sixth Circuit says that the T's are not a suspect class. And it was right to do so. Wow, Amy Coney Barrett coming out hard against the T's. T individuals do not constitute a suspect class, and it was right to do so. To begin, the T's is not marked by the same obvious, immutable, or distinguishing characteristics as race or sex. In particular, it's not defined by a trait that is definitively ascertainable. The plaintiff plaintiffs here began to experience dysphoria at varying ages, some from a young age, other not until the onset of puberty. Meanwhile, the T's acknowledge that some T's detransition later in life, so it's not immutable. According transgender status does not turn on an immutable characteristic. So those words just come out, sometimes out of nowhere. They kind of just hit you across the face. Anyways, nor is the transgender population a discrete group. Amy Coney Barrett unloading on the T's right now. They're having a meltdown, saying instead, like classes, we have declined to recognize as suspect. The category of T's is large, diverse, and amorphous. That's for sure. The World Professional Association says the term T's can mean whatever. Alito also says the T persons do not qualify as a suspect or quasi-suspect class, so blown out. Though his analysis differs in emphasis, I understand it to be consistent with mine. They are not protected. The APA similarly uses the phrase called the trans youth as an umbrella term to describe basically anything. They got like 57 different, drop downs on their little forms. Finally, holding that T's constitute a suspect class would require courts to oversee all of the policy choices involving the T's. They also agree that T's implicates physical and mental health. Indeed, this case is about the medical treatment of children. The question of how to regulate the medical condition of children is appropriate, saying what are the risks for kids? What age is this appropriate? Lots of questions. What about surgeries? Can we chop them off? Expert disagreements. Like if you can just take drugs, why not just have a surgery? Just chop the whole thing off like as young as possible, right? Like if it's good for them, why do you take pills? Just go do it. Oh yeah, because people would throw their guts up. Much easier to just shove a pill down someone's gullet. By contrast, the guidelines promulgated say this is a problem. They don't even have the capacity to give informed consent, and so their abusive parents are conducting it on their behalf. Beyond the treatment of dysphoria, T status implicates other areas of legitimate regulatory body, ranging from restrooms to eligibility for teams, sports teams. If the laws that classify based on T status trigger heightened scrutiny, it's going to become the business of the courts to get involved in all of the T lawsuits, because there are going to be about 1 trillion of them. They say that this is discriminatory, but this is mistaken. For the purposes of the 14th Amendment, there's no long-standing pattern of discrimination in the law. Existing suspect classes had a history, right? Everyone else has actually been attacked and discriminated and oppressed, but not the T's. Amy Coney Barrett sending the T's off. I mean, even John Roberts and Clarence Thomas weren't coming this hard, like not even close. I want to clarify the T's are not a class at all. It was rational basis. We should pass sports laws, all the things. The distinction between de jure discrimination and private animus is very distinct, and that's not happening here. Saying, we have said little about the powerlessness also of new suspect classes. Saying, because the litigants assumed that evidence of private discrimination would work, they didn't thoroughly discuss whether they have suffered a history of de jure discrimination as a class. And so, in future cases, Amy Coney Barrett says, I would not recognize a new suspect class absent a demonstrated injury of actual de jure discrimination. Wow. The Equal Protection Clause does not demand heightened scrutiny of these laws that classify even based on the trans status. So Amy's going even further than Roberts. Roberts is doing this thing where he's splicing it based on kind of the effects of the law. Like the law is very specific. It's about age and medical treatments for minors. Like that's it. Doesn't even talk about the T's. T's can do whatever they want over age of 18, but for minors, it's about medical condition and minors, the age. Amy Coney Barrett is going even further. In other words, you could pass a law that just says actually T's are not allowed on women's sports teams. So bye. And says T's, okay? Laws, Equal Protection Clause does not demand heightened scrutiny of laws that classify based on the T status. Amy Coney Barrett. Rational basis review applies, which means that courts must give legislatures flexibility to make policy in this area. Wow, amazing ruling from Amy Coney Barrett. You know, when she hits, she hits. But here this came out from Sotomayor. She says, any law that treats people differently based on sex is something that warrants heightened scrutiny. And so she's just going to say, well, their T adjustments is sex. And so sex has already been included in Supreme Court precedent. And so since the T's are actually a sex category, she's just shoving them in that bucket, not creating a new bucket for them, like in the intermediate class, just saying, no, it's a gender issue, shoving it in there and explaining why. So a lot of it is going to be about how it's horrible, and tragically studies suggest that many attempt suicide. And I think the numbers are also pretty bad after the transitions too. Here, suicide in particular is a major concern for parents of T teenagers, as the lifetime prevalence of suicide among transgender individuals may be as high as 40%. Yeah, it's pretty shocking. Like, why is that number? Now, the pro-T people would say, well, it's because they haven't transitioned. The people who are concerned about transitioning minors with permanent mutilation of their bodies are concerned concerned about the aftermath of the transition, whether those suicides are happening after the fact or whether it is a deeper problem in the root of the home. For example, if you have a parent who says, actually, we're going to chop your chest off when you're 12 years old. Maybe that's another concern. Anyways, so that's the decision from the Supreme Court of the United States. Pam Bondi was excited about it. She said, I applaud today's Supreme Court decision that allows states to protect vulnerable children from genital mutilation and other so-called gender-affirming care. That leaves children permanently disfigured and scarred. And many on that left party, for some reason, just don't really care all that much about the children. 300,000 that we know of trafficked across our border, not a big deal. You have now clinics getting paid hundreds of thousands and millions of dollars a year to conduct this mutilation of kids, and it's just all in the interest of a completely neutered and exploited society. And the Supreme Court, Amy Coney Barrett, says, we're not down with the tease, man. I haven't seen anything from her as aggressive as that in recent memory. No tease as quasi-classes or even suspect classes in any way, shape, or form, says Amy Coney Barrett, and the Supreme Court coming down today with, I think, a well-reasoned decision with a dissent, 6-3. There are going to be screeches about this for some time. We'll keep our eye on all the SCOTUS stuff. Thank you for subscribing and joining as we do.